important legal issues in Georgia, including auto accidents, personal injury cases, and criminal defense law. Here is your host, Attorney Jason Carnell.
Hey folks, Attorney Jason Carnell here again with another episode of my video or podcast. Thank you for tuning in. Today I'd like to talk a little bit about the retroactive first offender statute. Now this is something that just became available in 2015, and it allows for people who were previously convicted of felonies, who became convicted felons, to petition the court to retroactively treat them as a first offender. So I think this requires a little bit of background. First things first, what does it mean to be a first offender? Well, if you've never been convicted of a felony in the past and you're charged with a felony offense, and you don't want to become a convicted felon and lose all the rights associated with becoming a convicted felon, you can ask the court at the time of your sentencing to treat you as a first offender. And if the court agrees, if you're eligible and the court agrees, you are sentenced as a first offender, and if you successfully complete your sentence, whether that includes jail time, prison time, probation, or a combination of the three, if you successfully complete that sentence, at the end of your sentence, you are exonerated. The judge will sign an order exonerating you. That order will be submitted to the judge by probation, and exoneration means exactly what it sounds like. You were not convicted of the offense. All of your rights are restored. And your criminal history is automatically restricted. Now, long before I started practicing in 2010, but long before that, it was apparently uncommon for defense attorneys or the public defender's office to advise their clients of their right to seek sentencing under the First Offender Act. So back, we're talking basically like the 1990s and maybe the early 2000s, there were a lot of people who were charged with felonies who pled guilty to those felony charges without being sentenced under the First Offender Act, even though they were eligible and even though first offender was totally available to them. And so ever since that time, they've been convicted felons. Well, in 2015, the Georgia State Legislature passed a law allowing for these folks to seek retroactive first offender treatment. And it is exactly what it sounds like. You have to have already completed your sentence, but you can petition the court, the same court that sentenced you. Even if that judge is retired, that judge's old caseload goes before the new judge, whoever the new judge is in that county, to petition the original court to sentence you retroactively, to give you retroactive first offender treatment. Now, eligibility means, in order to be eligible for it, first things first, you have to have been eligible for it at the time you were originally sentenced. So if your criminal history includes an earlier felony conviction, then obviously at the time you were sentenced on the Georgia charge, you would not have been eligible for first offender treatment. Also, another prerequisite is that you cannot have been advised of your right to plead as a first offender at the time. So that means a couple of things. Number one, if your attorney told you about first offender way back when, and you said no, you didn't want to do it, then you would not be eligible for retroactive first offender treatment. If the court advised you of your right to seek treatment under the First Offender Act and you said no, then you would not be eligible for retroactive first offender treatment. And obviously what this is designed to do is to prevent people from taking the risk of pleading under first offender and yet getting the reward. So saying no, they didn't want to take the chance of pleading under first offender at the time, and yet later on down the road getting the reward of pleading under first offender. And then finally, if for whatever reason, way back when you asked for, when you were sentenced, if you asked for treatment under the First Offender Act and the judge said no, you would not be eligible for retroactive first offender treatment. Now, why would the judge say no? Usually it would require the prosecutor to intervene and object, and usually it would be, the objection would be based on either a long history of misdemeanors for which you were convicted. So even though you're eligible, it looks like you have an extensive criminal history, or perhaps a prior felony or two that for whatever reason you were not convicted of them. So it's possible that you could have received pretrial diversion for a prior felony, or perhaps conditional discharge for a prior drug offense that you've already completed the sentence on. And so technically you have not been convicted of a felony, but you have prior felony arrests on your record, which raises concern by the prosecutor that you should not get the benefit of first offender on this particular felony. So the prosecution would have to object, the judge would have to agree and deny you treatment under the First Offender Act. If that were to have happened to you, then you also would not be eligible for retroactive first offender treatment. So the law was really designed, the change in the law was really designed for those people who just, at the end of the day, they were eligible and they weren't advised. You see, today, if your attorney did not advise you of your right to plead under the First Offender Act, he would probably be committing malpractice. But that wasn't necessarily the case 20, 30 years ago. And so this law is designed to help remedy that past injustice where people were, legitimately get into trouble when they were young. They made a mistake. They paid their debt to society, and now this old felony is hanging over their heads and preventing them from advancing in their careers or getting jobs altogether. So if you have an old felony on your record that is haunting you and preventing you from getting a job or advancing in your career, I would advise you to consult with an attorney. Consultations are always free with my office. You can call me at 770-322-4990, or you can visit my website at www.carnellfirm.com. Thank you for tuning in, and I'll see you next time.
Thank you for tuning in for another episode. If you found this video helpful, please like and share it. If you have questions, remember, consultations are always free. Just call attorney Jason Carnell at 770-322-4990, or you can visit our website at www.carnellfirm.com.